Second, we are live. It's the Bradley J. Show, and yay, we are with Michael Coyne, Dean of the Massachusetts School of Law, and I've been saving him for this one because we're going to talk about the Karen Read case. We've both been following it very closely. Dean Coyne, his comments on it in the media, right? People have you on to talk about it, so you definitely are up to speed on this. And if this is new to you, the simple version is a woman named Karen Read is charged with the death of Officer John O'Keefe. She's charged with purposefully causing his death with a motor vehicle. And the defense has an alternative theory. Maybe you could outline what the defense says.
Sure. The defense's argument is, in essence, I'll borrow from their opening statement. She's been framed. They feel that she did not contribute to John O'Keefe's death, that she dropped him off at that house. Her story now is that she saw him go into the house and she never then saw him alive again. Her argument and the evidence she's now putting forward is that he went into the house. There was some type of altercation inside the house. He was beaten up there and then dragged to the front of the road where he was left for dead. That story is not the same that she was originally telling and that she's told on Dateline or even Fox 25 when her dad was interviewed. So there's been some changes to that. Well, and there's a big conspiracy between law enforcement and the homeowners and everyone else as she sees it.
What was her original story?
Her original story was that she's got a couple. She wasn't even there that night. When it was pointed out she was there, they saw her. Then it was, she just dropped John off and he left. And so the story has evolved a little bit. And even then the next morning, as they were searching for him, there's some great deal of disagreement as to whether she had already been to the house that morning, saw his body there, and then tried to get these other women to help her for her to concoct a story and for them to prove to be her alibi. So it's a mess all around. The case oftentimes leaves more questions than answers.
So those things contribute to the state's case, as does the fact that her framing story is, minus having seen what's gone on the stand, would seem far-fetched. However...
Yeah, go ahead. Yeah, it would take a lot of people is the problem to be able to...
I shouldn't say far-fetched. I should say the strength of the state's argument is that it's simpler than hers. And on the other hand, a whole litany of things have gone wrong for the state. And so what I want to do is talk about the strength of the defense's case.
Okay.
We've kind of already addressed the strength of the state's case, but there are some other things that have popped up. And so I have some kind of rapid fire-ish questions for you that talk about the strengths of the defense case. Basically the strength of the defense case is the stuff that cast doubt on the state case. You ready?
Well, that's correct, because they haven't even offered a defense yet. The government has to rest before they can. But just to explore the strength of the state's case just a little deeper, her blood alcohol level that night would have been incredibly high, would have been beyond the legal limit. The extrapolation the next morning says that she likely had 9 drinks that night, so her blood alcohol level might have been almost to the level, or not almost, to the level of blackout drunk. And the driving conditions were difficult that night, and there was struggles in their relationship. That's really what the government's case is.
Struggles in the relationship. I'm going to play, I hate to use the cliche devil's advocate, but struggles in a relationship. Lots of folks have struggles in their relationship, like half.
Absolutely.
Okay.
As I said at one point, join the club, right? Okay. We all have disagreements at times.
And so, yes, she's drunk. And that says maybe it's likely that she accidentally hit him.
Yes.
But that doesn't add to the likelihood that she purposefully hit him. And a matter of fact, might go the other way and say, really? She's blackout drunk. And she was able to back up accurately 51 feet at 24.5 miles an hour and hit a guy? Maybe it works the other way.
No, I don't disagree. I think she is grossly overcharged. They've overcharged her by including second-degree murder in it, which requires the level of intent or gross recklessness that we haven't seen yet. The likely charge, if the government can obtain a conviction, is the vehicular manslaughter charge, which, if that was grossly reckless in driving and drinking that night to cause such deadly consequences, then that's the best it gets for the government with respect to a jury verdict.
Okay. And by the way, a lot of people are watching us now, exponentially more than usual. Now I have a question from Phil Kate, which I think this question should be answered later on. So I'm going to show you the question now, but don't take time to answer it now. We'll answer it later. Is it possible a jury might believe she committed the crime, but equally convinced that the police are using nefarious means to implicate her and returns a non-guilty verdict? Yes, we'll get to that later on. And also, Joe says, I feel there are no saints in this case. I haven't seen any saints.
I think both commentators are likely dead on this. Is that oftentimes we end up with more questions here, and certainly the police have not covered themselves in glory with respect to their investigative techniques here.
Briefly, you mentioned she was overcharged. Now that's a mistake, because then you get into requiring a motive, right?
It is, but see, what it also has allowed them to do is introduce a lot of the stuff that makes her look not so good. The yelling and the abuse of him, the angry texts between them, and the level of their relationship, which makes her less sympathetic. And that's probably, at least in part, why they charged her with second-degree murder, because none of that would be relevant if it was just vehicular manslaughter. Also, I think they overcharged her with the expectation that most people facing life in prison, and that's what a second-degree murder charge would cause here, would look for a plea deal. Vehicular manslaughter, she gets out maybe doing even less than a year. Many people, without the resources or the wherewithal that she has, would fold and take the deal, and then none of us ever would have learned any of the abuses by law enforcement in this case.
Did they offer her a deal?
It's allegedly they did offer her a deal, and it's not unusual that you would, because as you can see, and as people can already see from the case, it's a difficult case to prove second-degree murder. The likelihood of a conviction on that count is, to me, extremely low, if not non-existent.
Can they still offer her or re-offer her?
They can make it any time before the jury comes in or before the judge rules on the defense motions for a required finding of not guilty. They can make a deal and they can resolve this. I don't see that, because the positions are quite hardened at this point. I think the reputation of the district attorney in the case is in part on the line here. And so it would be difficult for them to come up with some type of face-saving deal. It may be, again, the best it gets for the government under the circumstances.
Okay, now back into the specific questioning.
Sure.
The rapid-fire pepper with questions.
Okay.
Well, of course, there's the stream of offensive texts from Trooper Proctor, which were off the charts horrible. How much of an impact is that? Enough to make a jury just say, you know what? I never would have thought that this was possible, but now that I listen to what they said, maybe they are capable of that.
Yeah. In and of itself, it probably wasn't enough, but the case wasn't going in well before Proctor ever got on the stand. And that's the problem with it. If it had been an otherwise really strong case, you might have been able to survive Proctor's text messages and grossly inappropriate behavior and investigative techniques.
Is it surprising to you that, first I should ask, has he been censured in any way by the force?
No.
And if not, what does that say?
Yeah, not to our knowledge yet. They may, it wouldn't have been wise to censure him during the case, because that would have been a means of attacking him on cross-examination. But the likelihood is he will be seriously sanctioned if he's able to retain his job at all. They were well beyond the bounds of any decency And the likelihood is that if he's able to remain employed by the state police, it'll be somewhere where we never hear or see from him again. The problem with that is he is also the lead investigator on the Matthew Walsh case out of Cohasset. So it
Wow.
creates another problem as well.
So is it true that he was texting some of these to his superiors?
Yes, the superiors were involved in one of the text change and didn't stop it, didn't say anything, didn't reprimand him.
So couldn't they be on the hook for something?
Absolutely.
Okay.
There'll be multiple people should be disciplined from the state police before this is all over.
Next, when we're talking about the strengths and therefore the weaknesses of strengths of the defense, the weaknesses of the state's case, the investigators did not go into the house on the property where the body was found. That's insane. He was found without a jacket, correct? What if there were a jacket in the house? That would say he had been in the house, or that would add to the possibility that he had been in the house, which would change everything. Isn't that a heinous oversight? Or if it was not intentional, it was oversight. That's crazy. I understand that Trooper Proctor said, well, we didn't have a warrant, or we didn't have the justification for a warrant. But Trooper Proctor, you can go up and knock on the door and ask, did you do that?
They could have, but the point is that these people are aware of their rights. I would advise a client that I would not allow someone to come into my house based on just this, at the moment in the morning, they really had no information that he ever came in the house. She was, in fact, saying at that point that she had hit him with the car. She never said to any of the first responders that morning, I saw him go in the house.
Even so, it's up to the investigators to ask, even if it's likely they will be refused.
Well, they should. I don't disagree. They should have asked. But, maybe I lived in the city too long. The fact that there's a body outside near the roadway at my house doesn't in and of itself say he was in that house and that's where he met his end.
No, but it's worth looking into if you're really going to investigate that. I mean, that would be high on the list of stuff to do.
It is, except again, look at the facts that they had on the ground at the time. This person was saying, I hit him. Do we know that they had all been out drinking that night before? There wasn't a lot of evidence that the police would have that he had been inside the house. Would good police work have asked further questions? Frankly, if good police work had been employed, there very well would have been interviews inside the house, photographs potentially, and videos, and that would have saved, if in fact that he never went in the house, that would have saved the Alberts a great deal of aggravation and pain and abuse over the last years. The law enforcement didn't do the owners of 30 Fairview a service in this case either. The case was bundled from beginning to end.
Next, the state says injuries were caused by an impact that also broke the taillight. I saw scratches and holes in his arm.
Yeah.
And if there were an impact enough to cause as much trauma, let's forget how the holes and scratches are weird, but if there was an impact enough to cause that trauma and the taillight was part of that, there would be some DNA. There would be tissue. There'd be blood tissue, skin tissue, other DNA tissue on that. And I haven't heard about that. There being
DNA. There is DNA. They did find a hair on the taillight that matched to John O'Keefe. But we're talking about a minuscule amount of DNA on that taillight, and also the taillight having survived a 60-mile round trip from Canton to Dighton and in a snowstorm. So
the hair on that surviving that's weird.
It is, and that again leads to more conjecture and speculation about the planting, the framing of the defendant by the planting of this evidence, as opposed to, well, they discovered it timely. Again, law enforcement should have taken greater steps to preserve both the crime scene and what they, at that point, were believing was the instrumentality of death. And they didn't do a good job on it. And that's why we've got all these questions about a conspiracy and whether, in fact, she's being framed, and whether the opposite, whether she is a cold-blooded murderer that is clever enough to to blame the people that at one point were her friends.
Okay. Folks, by the way, we're with Dean Michael Coyne, Dean of the Massachusetts School of Law, and my pal. And we're going to just take a quick break for a question from a viewer. Can Karen Reed bring civil suit against MSP for her injury to her reputation resulting from their texts?
Not likely, because here's the question that at the end of the day, the jury has to decide. Was she guilty beyond a reasonable doubt? Even if they return a verdict that she's not guilty, that is not a verdict that she's innocent. And I know people would like to hear the jury say that. That's not the way criminal cases work. So the question then becomes, well, did the state police, did the government, did the Commonwealth of Mass have enough evidence to charge her to believe that there was a reasonable grounds to believe she committed this act? Well, again, go back to the evidence of the drinking, the driving, the deadly consequences, and her admission that she hit him. That's what she said.
In these questions, we're not talking about her damage to her reputation from the charges, but from the texts.
Oh, damage from the texts themselves?
Yeah.
I don't know. See, that a lot of that, it's nasty, but it's opinion. And it's very difficult to win a defamation case based on opinion.
Right. Okay. I guess you'd have to prove that the things they said were not true as well, because the truth is a defense. Right. All right. The evidence collected over a period of days, like the taillight, sat in the snow and gradually became uncovered over a period of days, which is not really great for the chain of evidence. That area was left unattended for periods of time, right, while the snow melted. Is that true?
It's atrocious. It's atrocious.
What,
you don't have, you don't have one of those athletic tents that we see all along the soccer fields and the like, to be able to keep further moisture and everything off the crime scene.
Yeah.
You don't have heaters. You have a snow blower. That's how you're discarding the snow to get at the evidence, how you're losing likely hair and potential other DNA evidence by doing that. There's no justification for a lot of what law enforcement did here whatsoever, and that's the problem. From collecting the evidence in red Solo cups, to the snowblower, to the preservation of the Lexus and the taillight, there is no justification for how this was done.
Okay, what about the puncture wounds? The testimony today from an expert said that, in her opinion, those are dog bites. And how does that factor in? What if, in fact, it's true? And why weren't those tested for the DNA of the dog?
They were.
Oh, they were. And how'd they come up?
No dog DNA, no canine DNA was the
really?
Testimony. Yep. No, there was some evidence of pig. But no canine DNA. The pig could have been from something he ate. He was a sloppy eater or whatever, but there was no canine DNA. But the expert today was quite emphatic that they, in her opinion, they appear to be scratches and potentially puncture wounds from a dog. But again, remember, now this is opinion. It's based on her background, education, experience, and training. And it's a great get for the defendant, but it doesn't mean that is in fact the gospel. She didn't see it, nor would any expert see it.
Right.
And the likelihood is, and this is what I'm wondering, which I don't know why it didn't come out today, just so you'd know for when the jury's present, experts normally are paid, usually paid quite a bit of money. Where she came forward and volunteered, she might either be paid or she might just want to get involved in the case. And that appears to be what Judge Coyne is a little bit worried about. Is this one of these folks that gets attracted to the high-profile cases? That's
what the prosecutor was getting at. It's like, when did you see this case? Did you volunteer after you read about the case, kind of thing? Any one of these things, by the way, could constitute reasonable doubt. Let's go to the injuries. The puncture, the injuries don't look like the side of a car or a taillight, right? Regardless that there's no dog DNA, they still look weird.
I appreciated Trooper Paul's testimony the other day because I didn't quite understand how his injuries would be consistent with being hit by a car. But what he was saying, in essence, is the car brushed, as I heard it and as I'm interpreting it, that the car brushed his arm at a high rate of speed, and the taillight broke during that, and the broken taillight scratched his arm like that and sent him to the ground.
And punctured his arm,
And
I guess.
and cut his arm in various places. Makes a lot more sense to me than a lot of the rumors we saw on social media and the like about how he was hit by the vehicle. Because again, you don't have extensive damage on the vehicle, nor does he have extensive damage that would be consistent with being struck by a vehicle at a high rate of speed.
All right. State alleges. Oh, the state alleges that a glass was found in his hand, right? Like a drinking glass, a cocktail glass. Is that what they mean?
Under his body, yes, a cocktail glass from, I think it was the Waterfall Bar.
And is the state alleging that he was hit by the car while holding the glass and held onto the glass while being thrown 12 feet in the air?
Yeah. That sounds close to what their theory is, if not that the glass landed under him as he was thrown when he was hit by a car. Both the glass and his cell phone.
And his cell phone.
And again, that's why people say that strains credibility if the fact is that he's hit by a car going 20 plus miles an hour in reverse. And by the way, I tried that this morning. I could do it, but man, it's scary. And so it's a tough theory to sell, I think. Go in reverse and put your pedal down. When you start to get north of 15 miles an hour, it's a scary journey.
Yes, and you're drunk in a snowstorm. Could you hit it?
Yeah.
Could you hit it, Target?
This morning in our parking lot, I hadn't been drinking yet.
And well, there's also this isn't if I saw somebody coming at me, I would jump out of the way.
Right.
So, next, they made a big deal out of the search, asking about how long can a person survive in the cold. Like, that seemed to be a sign of guilt, right? To me, it's not. This person is missing. It's snowing out. I don't know where they are. I hope they're not in some snowbank somewhere. I'm going to search how long someone can last in a snowbank. Because I don't know, maybe he was drunk too.
No, the importance of that evidence, or the question of that evidence, is what time was the search made? The defense is arguing that search was made at 2:30 in the morning before anyone knew he was missing. And it is the prosecution's evidence that says no. That was done at 6:30 at the defendant's insistence. Jen McCabe had nothing to do with this murder. The fact is that the only reason it shows on her phone is that the defendant asked her to look it up because she was now worried about it. And the argument as to why at least there's unsettled evidence of what time the search is that she had a tab open from the night before, and the way Google and all the rest of them do it is if the tab is open, it doesn't always show the new time of search. It would show the time the tab was open. Way beyond my ability to tell you how that all works or is accurate. That's why they've got dueling experts on it.
And maybe difficult. It's pretty dense. Maybe difficult for a jury to comprehend, which is
it is, except
factor.
It was powerful evidence if in fact the search is at 2:30 in the morning when his body isn't discovered for 3 more hours. That's why it shifts the blame as the defendant sees it to this other group of conspirators, and that's why it was a pretty solid piece of argument that supports the conspiracy.
Right.
The expert the other day seemed to answer that pretty solidly. The defense will have their own expert to say, no, that search was at 2:30.
I will get to some of your questions in a bit. I want to gain some ground here because there's a lot to get through. Yes, that thing you just mentioned was a ding on the defense. Definitely, that was something from yesterday, I guess.
Yes.
Now let me.
But Bradley, the whole point of that is, though, anyone who testifies with a British accent, we always give it more credit than it should. It just sounds more intellectual.
Absolutely true. What other? So there's a weakness for the defense, a ding. Anything else that may have been a mistake by the defense, or both in making a decision or in the way they do things? Or is there something that the prosecution did that was difficult for the defense? Any other difficulties for the defense?
I mean, I think I think the defense generally has done a superb job. I think most of what they do with respect to questioning witnesses and making arguments and offering evidence is textbook. It's what we teach. My only slight criticism is early on, and this is the case though, is that they said to the jury that Karen Read was framed. So the question then becomes, though, do they actually have to prove that she was framed to the jury in order to be successful, to get a not guilty verdict? Because they don't, as a defendant, you don't have a burden of proof. All you have to do is show that the government didn't meet theirs. And so I do wonder a little bit whether they set a higher bar than they should have, because I think most people look at this and see it as a reasonable doubt case, that there's just so many questions about so many things. You wouldn't want to be able to put someone away for the rest of their life, because you can't say with a moral certainty that she did everything the government says she did. And so that's the only question I had and that will be interesting to see if the jury returns a guilty verdict. And I think it'll be vehicular manslaughter at best. I think it'll in part be because they're not buying the wide-ranging conspiracy and the framing. They see it likely more as an accidental death, having been brushed by the car.
All right. That's a very good point. Let me get to some procedural questions. Stuff I see at the trial, and I say, why are they doing that? You'd think I know because I talk to you so much, but I don't.
Okay.
This one you did answer for me, but I want you to answer it for everybody else. Why, when attorneys object in this particular case, do they not state the grounds? I would like them to state the grounds because I want to learn. Think, that was calling for a conclusion, or that was asked and answered, etc. So why don't they give the grounds?
Well, I'm actually hoping to talk about this tonight too on NBC 10. Some judges only want you, when the jury is present, to state objection and nothing more. Other judges would allow you, with the jury present, to say objection and a grounds, hearsay, leading, cumulative, whatever the grounds are, you could state that, but nothing further. No what we call talking objections, because she doesn't want the jury to be tainted by the arguments on evidence that they may never hear. And so what she's been doing is just simply having them make their objection, and then she rules on it immediately. If she needs more information, she will ask the lawyers to come to sidebar and then hear more argument. Or if the lawyers want to be heard further, they can ask to go to sidebar outside the presence of the jury. The jury can't hear. They're talking in whispers at that point. And so the jury doesn't hear the information that they're arguing about, whether it should be admissible or not and what the reasons are.
Okay. Today's testimony, the jury was not in. At least the part I saw when they were talking to people, it was under voir dire. But, we always think of that as in terms of jury selection. And is it related to the actual meaning, speak the truth of voir dire? Is that what that means? And why does that phrase apply to the questioning of these potential witnesses?
Well, because the court is looking to obtain a foundation for whether the evidence should be admissible or not. Since it's done outside the presence of the jury, it is considered you are allowed to voir dire the witness with respect to foundational elements. And in these cases today, the two different sets of witnesses, the first one was a question of whether the defense violated the rules of discovery. Trials are supposed to be a search for the truth. At least that's what we say. But they're not supposed to be trials by ambush. And the prosecution was arguing they never disclosed this witness or what she's going to say prior to really today. They disclose the name, but there's no reports or anything else, which makes it difficult to prepare for cross-examination. So they were arguing in the first trial that there was a discovery abuse and the sanction should be that witness doesn't get to testify. In the second group of witnesses, the three who are accident reconstruction experts, the voir dire was with respect to the foundation as to whether these people are sufficiently qualified by background, education, experience, and training to offer their opinion, because it is opinion by experts. And so she wanted to know, the judge wanted to know and get that foundation before the jury ever hears any of it, is A, as to their qualifications, and B, what exactly did they do while they may be qualified? What exactly did they do to obtain the information and arrive at an opinion? Is it sufficiently trustworthy that we should admit it in this case? So the second set of voir dire was simply about the potential admissibility of the evidence when the jury gets present, so that they can lay that foundation both with respect to their level of expertise as well as their level of work on this case that makes it trustworthy that the jury should receive it and that it will aid the jury in their understanding of the event.
Next is kind of a nuts and bolts question. What's the woman doing speaking into the thing that looks like the oxygen mask? Is she just simply repeating everything that gets said?
Yes.
Really?
Yeah, yes, that is the stenographer. We're all used to the more traditional way of typing it all in. But that actually is probably at least about maybe north of 30 years old now with that method, where, yes, they say everything that's said, and then that is ultimately transcribed. My guess these days, at least the first transcription, is done by computer, and then it has to be edited in, comparing the recording to the actual transcript that comes about, likely with the aid of the computer at that point.
I wonder why they don't just record it. Have Mike, everybody.
They are recording it as well. There is an electronic recording, but it does seem kind of odd these days that if you've got the recording, and we know that we can get through Dragon or some other software pretty accurate transcription. We do it with Zoom and StreamYard and all the rest these days. Why we need that additional step. But again, it's a murder case, and you do want to know, you do need and want to have a verbatim record of what actually was said by who and when.
Okay. This is finally an observation before we get to the questions. If you're going to have this live and you're going to mic the judge and the witness, can you please mic the attorneys, the counsel tables better? Because you can't really hear what they're saying. I mean, it can't be that hard. I mean, there are nice mics you could have right on the table there that would probably be better.
I would agree. My tech people, I'm sure, would agree wholeheartedly. You know, the fact is, we're trying this case in one of the oldest courtrooms in the Commonwealth. Sacco and Vanzetti were tried here.
Wow.
It's small. It's antiquated. As you can even see, the present setup is, to me, lousy. We have some in Suffolk Superior like this as well, where the one group of lawyers is in front of the other, and it's hard to see the jury. The fact is, we have a lot of antiquated courtrooms in the Commonwealth of Mass state system. Nothing equivalent to what we see in the federal court system here. We have one of the most gorgeous federal courthouses in the country, and has high level of technology and a high level of comfort for both the lawyers, the witnesses, the families, and everyone else. That's oftentimes not what we see in the state, unfortunately.
Oh, I do have one more. Is the FBI involved in what way? In what way? And how and why?
Yes, they are involved. The testimonies today said that these accident reconstruction experts were in part given information by the FBI and the Department of Justice. We really don't have as much information about that level of involvement and why this was done. at all. I'm sure at some point we'll gather more information on this, but it's very unusual to have the Department of Justice and the FBI involved in a pending state court case. Some argue that it's about reviewing the district attorney's role and what they're doing out there. Again, we don't have enough information as to why that happened, but they're the ones that procured the experts that were part of the hearing today, the 3 experts who were accident reconstruction folks, highly educated, highly skilled. My guess is that cost the federal government an awful lot of money to get those answers. So they must have some significant interest in the case as to why they would have done that.
Okay, let's get to the questions. I appreciate it. Questions and comments. Phil Kate says, the ghost of Mark Furman. He must be referring to Trooper Proctor. We mentioned that before, and you did mention that there are parallels between this and the OJ case, and that's one of them right there.
I think that's right. I mean, remember, OJ was found not guilty, and he was found not guilty in less than 4 hours. That is significant part based on police misconduct. I don't think it's unfair to say that are we looking at a similar situation here where the jury might have decided that the Commonwealth's evidence just doesn't add up to beyond a reasonable doubt. And that's the question, is that will we see the same result? Same thing with Casey Anthony. There was a big question about police conduct and whether they had done their job properly. She was found not guilty in less than 9 hours. I think if I were representing the Commonwealth at this point, I'd be worried that this police misconduct and malfeasance may well have been the end of the case.
Okay, and Joe talks about the missing 13 minutes. I didn't bring that up, and I'm fuzzy on the missing 13 minutes. Does that ring a bell for you? Is that in the tape?
I think he means
took place in the garage.
The Sally Port, the video surveillance of the Sally Port, where her vehicle was taken to be examined and stored to determine whether any of his DNA was on the vehicle and what other scientific information they could extract from that vehicle. The camera is not a running time. It's supposedly only videos on motion, like your Ring camera, say. So there are gaps in the tape. And even when you're watching the tape, you see people sort of disappear into a wall and come and go with no explanation, almost as if they're ghosts. And that's, again, raises this whole issue about did someone edit the tape? What's going on here? And I don't think, in fairness, it's really been adequately explained, and certainly not adequately explained to those that are distrusting of the government's case to begin with.
So the answer to that may be that it's a camera that is motion activated and turned on for a certain period of time and turned off, and it's not activated until somebody else.
That's what one of the officers testified.
Yeah, but you're right. Reasonable doubt. I mean, when you get any sort of missing footage, your hackles go up, like Watergate, etc. So this has been a fantastic discussion.
Wait a minute. There was another question, though, that we said we were going to wait till the end. Is it possible that she did it, but that
there it is,
police misconduct, that the jury is going to come back with a not guilty?
So there it is, and go ahead, and your answer is?
They're not mutually exclusive, are they? I mean, both parties here that see this case as they see it. Hey, she definitely did it. She was drunk and she hit him. That, in fact, that happened. And also that the police, and trying to help out a fellow cop and who was worried maybe about civil liability with a dead body on his lawn, and were so inept that they didn't even know how to preserve the evidence of the crime scene, that the jury could say, well, she might have done it, but might have isn't the standard. The standard is beyond a reasonable doubt. So the question is a good one. They're not mutually exclusive. She could have done it. We still could be looking, and likely looking at, a not guilty verdict, in my opinion.
Wow. But there's more than one charge. Not guilty on the big charge, guilty of the others.
No. Not guilty. Second degree murder absolutely not guilty. Vehicular manslaughter, it's still not guilty in my opinion. They got a little bit of fighting chance on that. The last one would be related to the vehicular manslaughter charge. It's leaving the scene after having caused bodily injury or death, and they could settle on that, but then that means that they've still decided that she did hit him with the vehicle, and if she did, and they find she's drunk, and the evidence is pretty convincing that she was, then that would mean it should be a vehicular manslaughter conviction as well.
What sort of plea is most likely? Would it involve time? And if so,
yes.
what's the likely amount of time?
Well, I don't think she's going to plea. I think they've convinced themselves that there's not a chance that this jury will come back.
Okay.
And that may be correct. But if it was, she would be having to look at serving, or at least a sentence, say, of maybe 14, 16 months. But again, with good time and all, she would serve less than a year, which I know it sounds hard, but if you're facing life in prison, right, and you're not even eligible for parole till 15 years passes at the minimum, that's not, I always ask my students, suppose you were 100% totally innocent, but the government offered you a deal that you need to either serve 3 months or no months, but you've got to admit to guilt. Would you take it? If you were facing a life imprisonment sentence, I think many of us would, even if we were completely innocent, simply because do you trust the system will arrive at the right result? And there's people in jail who trusted the system and it didn't work out.
Okay, that said, if it were you, if you were the defendant, given what you know about the law and how things usually work out, and given the circumstances of this case, if it were you, and they said, I tell you what, 14 months you admit guilt, or you take your chances with the jury and the murder too, what would you do?
I'm taking my chances because I do not see a murder. I do not see a murder to verdict.
Okay.
I do think there's a slight chance for vehicular manslaughter. The problem is, I think the government has tried a horrible case from beginning to end. They've wasted the time of the jury on, the first 2-3 weeks worth of witnesses weren't needed at all. And so I do think the jury has arrived at what they think took place and now are looking for information to support that decision. And the problem is the government's strength of the government's case came too late. Now, we're not done yet, but we're pretty close to the government resting. Now, they may well rest by the end of the week. Thursday is one suggestion that they may rest come the end of Thursday. And then the defendant will make a required finding of not guilty. Judge will consider that, but likely the defendant will put on a case the end of this week, beginning of next, which will include those experts that we saw interviewed today by Guardia.
This has been maybe one of the very best segments I've ever done. This is so much information, succinctly dealt with in a reasonable amount of time. It was great, and it's been the most popular one of my broadcasts ever.
Oh, good.
I mean, one of my online broadcasts. So.
Oh, great.
So clearly there is huge interest in this case. It's got it all. It's local and it's global, right? This is a global thing.
Yeah.
It's got the drama. It's got the woman, and her attractiveness probably plays into it, etc. It's got it all. It's got the Mark Furman. It's got the OJ, the whiff of OJ.
Conspiracy. Everyone loves a good conspiracy. It's got, It really does have. I do really believe it's this generation's OJ, and it's unfortunate, frankly, that it's shown our Mass State Police in such a poor light, because this case doesn't illustrate the strength of law enforcement in this Commonwealth at all. Unfortunately, it's a very bad representation of a small group out there.
And it is unfortunate that police departments are having trouble recruiting as it is. This is not going to help recruiting a whole lot.
No.
Okay. Appreciate your time, and have a good session tonight on TV. Which TV station are you on?
NBC 10 Boston. We do Canton Confidential.
What time?
7 o'clock.
Okay, be there.
Thanks.
Take care.
See ya.
I'm going to end the stream, but don't leave me.
I won't. It's always